Hi, everyone. Thank you for joining us this afternoon. The IIB is thrilled to host this 1-hour webinar with Clifford Chance. In this program, we will hear from Clifford Chance partner David DiBari, who is a global co-head of the firm's international risk team. We will also hear from Philip Angeloff, who is counsel in the firm's U.S. Financial Services Regulatory Group. Also joining the discussion is Jackie Landels, who is counsel in the firm's Washington, D.C. office. They will provide an overview of current issues arising under U.S. sanctions against Russia, with a focus on recurring compliance issues, challenges and risks for internationally headquartered financial institutions. We want to make today's session as interactive as possible, so please submit your questions throughout the program using the Q&A feature located at the bottom of your screen. David, Philip, and Jackie, before we begin, I want to thank you for joining us today and sharing your knowledge and expertise with us. We're excited to hear from you about this important and evolving topic. And thank you very much to Clifford Chance for supporting the IIB as a gold level member. We are stronger because of your membership. With that, I'll hand it over to David to take it away.
All right, well, thank you very much, Beth. It's exciting to be here today, and we've got a lot of ground to cover. So we're going to jump right into it. Jackie is going to lead off for us with a sort of an orientation on sanctions with a focus on what's happening with Russia right now. Then Phil's going to talk about some of the key issues we're seeing for clients involved in transactional activity across a variety of different types of matters. And then I'll focus on what we're seeing in terms of enforcement trends, what's happening now and what we think is going to be happening in the near to medium term. And with that, I'll turn it over to Jackie.
Thank you, David. Good afternoon, everyone. Thank you for joining us today. I wanted to kick off the session with a brief introduction to US sanctions, discussing some of the key concepts which are going to be important to understanding the US sanctions against Russia. I'll then go a bit more in depth into the current US sanctions against Russia, focusing on those that have come into place since February 2022. So, high level, the US sanctions are primarily administered by the Office of Foreign Assets Control, or OFAC, of the US Department of Treasury. But we also have the US Department of State that administers certain sanctions programs, and the US Department of Commerce that administers export controls and an export licensing regime for so-called dual-use goods. So focusing on OFAC sanctions for now. There are two broad types of OFAC sanctions. The first are what we call the primary sanctions, and those are the jurisdiction-based sanctions that apply when you have a US person, the US financial system, or other US jurisdictional element involved in a transaction. The second type are what we call secondary sanctions, and those are sanctions that authorize OFAC or the US Department of State to impose a sanctions designation on a non-US person for engaging in certain types of sanctionable activity, even if no US jurisdictional elements are involved. So as an example of the primary sanctions, if you have a US person engaging in a transaction with someone on OFAC's specially designated nationals or SDN list, that's when the primary sanctions are going to come into play because you have a US jurisdictional element involved with a US person. In contrast, if you have a non-US person engaging in a purchase of Iranian origin oil, that's sanctionable activity under the US secondary sanctions, even if you've got no US elements involved. The OFAC primary sanctions fall into various different buckets. One of these is countrywide sanctions. There are also list-based sanctions and sanctions that prohibit certain types of transactions or activities. I think the most well-known are these countrywide or territory-wide sanctions. Shown on this slide are the jurisdictions which are impacted. In relation to Russia, which is our topic for today, we have the Crimea and the so-called Donetsk People's Republic and Luhansk People's Republic regions of Ukraine, which are comprehensively sanctioned. Those regions have declared themselves independent of Ukraine, and the US government decided to sanction them. Now, one question I often get is, what about other regions of Ukraine which are currently controlled by the Russian military? Some of you may be familiar with EU sanctions, which cover more broadly, the whole of the Donetsk and Luhansk regions of Ukraine, as well as other regions which are not controlled by the Ukrainian government. So currently, the US sanctions do not cover more broadly those areas. One reason may be that I think situation changes day to day, week to week on the ground in terms of what area is controlled by who. But we're still waiting to see if the US might at some point expand the territories which are covered by these comprehensive sanctions. So that's one to keep an eye on. Next, we have the list-based sanctions, and these target individuals, entities, and sometimes aircraft or vessels, which are associated with certain countries under OFAC sanctions programs, such as Myanmar or Nicaragua, or they can be associated with certain types of activities, such as terrorism, narcotics trafficking, or cybercrime. The main OFAC sanctions list is the Specially Designated Nationals List, or SDN list. In relation to Russia, we also have sectoral sanctions lists. The main one is called the Sectoral Sanctions Identification, or SSI list, but we also have some new sectoral sanctions lists that have come into existence in the last year and a half, which I will talk about later on in the presentation. We also have lists of export restricted parties, which are published by the US Department of Commerce and US Department of State. They're a little beyond the scope of today's presentation, but just as a high-level overview, the US Department of Commerce has added a number of Russian entities to its export restricted lists. These include the entity list, the military end user list, and its denied persons list. I think what has received a lot of headlines might have been a lot of Russian airlines have been added to the denied persons list and denial orders issued against them. And generally what that means is that the export of some or certain types of goods, software, and technology are prohibited without a license. When those goods, software, and technology are controlled by the US Department of Commerce, such as US origin goods, or goods containing more than a de minimis amount of controlled US origin content. So I've mentioned the SDN list, and I wanted to just flag this because it's such an important concept. OFAC can list individuals and entities on the SDN list, thereby imposing blocking sanctions on them, meaning that US persons have to block the property and interests in property of those individuals and entities when it's in their possession or control. So by interest in property, these sanctions also capture entities that are owned 50% or more directly or indirectly by SDNs. And I think this is a concept which many of you will be familiar with. OFAC does not list all these blocked persons on the SDN list. So conducting due diligence, both for financial institutions and companies, is very important to try to identify if your counterparties are actually 50% or more owned by SDNs. In general, the blocking sanctions prohibit US persons from engaging in transactions with blocked persons unless there is an OFAC license or an exemption authorizing the particular transaction or activity. I've mentioned US persons a couple of times, so I wanted just to explain that concept as well. OFAC requires compliance with its primary sanctions for all US persons, and that can be US citizens and US green card holders, wherever they are located globally, including dual nationals, anyone who's physically located in the United States, even temporarily, regardless of their citizenship. So if you're a French citizen working in France, but you come to the US on a business trip or on holiday, during that time, you're temporarily in the US, you become a US person with compliance obligations under OFAC sanctions. US persons also capture US companies, US domiciled entities, and their non-US branches. Non-US persons are not off the hook, though, for OFAC compliance when it comes to primary sanctions. OFAC requires non-US persons to comply with the primary sanctions when they involve US jurisdictional elements in their transactions. That can be US persons, the US financial system, US territory, and in certain cases, US origin goods. I think one situation which many people on this call may be familiar with is that OFAC asserts that primary sanctions apply to transactions that process through the United States. So for example, US dollar SWIFT payments that process through a clearing bank in New York, even if they originate and terminate outside the United States, because they come through the US, OFAC has jurisdiction over those payments. The involvement of a sanctions target in those transactions potentially could violate OFAC sanctions. Another concept, which is, this one is important for the Russia sanctions, is the facilitation prohibition. So OFAC generally prohibits US persons from facilitating transactions that of non-US persons that the US person is prohibited from engaging in directly under OFAC sanctions. So to break that down a bit, what that means is, for example, if you are a US citizen and you work for a non-US company outside the United States, that non-US company only has OFAC compliance obligations when it's got involving US elements in its transactions. So the US company, for example, would not be prohibited by OFAC sanctions from selling widgets to Cuba, as long as it excludes US elements from those transactions. But as a US person employee, you are prohibited from facilitating that sale unless there's an OFAC license or transaction. And that can mean approving the sale, authorizing it, supervising someone engaged in that, or actually doing any other activity that moves the sale forward. I also mentioned the secondary sanctions, and that may be relevant for some people on this call. These are the sanctions that OFAC and the US State Department can impose on persons, non-US persons, who engage in certain types of sanctionable activity. This is a relevant concept for the Russia sanctions. There are a number of different types of activities in connection with Russia that are sanctionable under the US secondary sanctions. Some examples are investments in Russia's energy sector, transactions related to Russia's energy export pipelines, and significant transactions with certain Russian SDNs. The secondary sanctions differ from the primary sanctions because they seek to deter non-US conduct by non-US persons that's outside OFAC's jurisdiction. That conduct would not violate US law, but it exposes the non-US persons to a risk of retaliation by the US government in terms of a sanctions designation. And the type of sanctions that can be imposed vary depending on the sanctions program and the type of activity. But in the worst case scenario, it can include an SDN designation. Also wanted to talk a little bit about the material assistance trigger. In almost all OFAC sanctions programs that provide for blocking sanctions, there is a concept of OFAC having the authorization to impose a sanctions designation on persons who provide material assistance or support to blocked persons. This is not something that OFAC has traditionally used to impose SDN designations in the past, but we have seen it done so when it's compelling national security, foreign policy reasons, or strong US political incentives to do so. But what this means is that engaging in a transaction with a blocked person, in many cases, can expose you to the risk of a sanctions designation, even if you would not traditionally have thought that it was covered by secondary sanctions. On the right side of the screen, we have an example. In December 2022, OFAC designated an individual under the material assistance provision for having been involved in Iranian oil sales on the basis that it was providing material assistance to Iran's Islamic Revolutionary Guard Corps, which OFAC had previously designated as an SDN. There are a few other examples, but as I said, they're not very many, but the risk exists. So diving now into a bit more on the Russia sanctions themselves. So before 2022, there were sanctions against Russia that had been in place primarily since the Russian annexation of Crimea in 2014. But the sanctions have significantly increased since February 2022. One area where there have been very significant increases is in the number of individuals and entities listed on OFAC's SDN list. We've seen a number of major Russian financial institutions added to the SDN list. I'm sure the names on the screen will be familiar to many of you: Sberbank, VTB Bank, VEB. We've also had a number of Russian oligarchs, politicians, and companies added to the SDN list. And as I mentioned, with the SDN list, you have to be careful about not only engaging in transactions with companies or people on the list, but also entities owned 50% or more by them. So we capture a lot of entities in Russia are captured by these new SDN designations. Other key US sanctions on Russia that have come into play in the last year and a half. As I mentioned, we've had territory-wide sanctions. The ones against Crimea have been in place since 2014, but the ones against the Donetsk and Luhansk People's Republic regions have come into place since February 2022. And those generally prohibit US persons engaging in all commercial transactions with those regions, persons located or domiciled or resident in those regions, unless there's an OFAC license or exemption. We also had, even before 2022, sectoral sanctions, and those targeted a number of Russian companies in the finance, defense, and energy sectors primarily, and they prohibited different types of activity. The one which we've seen of most interest to financial institutions clients are ones that prohibit US persons from dealing in debt of the companies, such as loans or extensions of credit to those companies over a specified number of days. Certain of the sectoral sanctions also prohibit dealing in equity of the sanctioned companies. And this is what has sort of crystallized, come together in the new sectoral sanctions under Executive Order 14024 Directive 3. They prohibit US persons from engaging in transactions or providing financing for dealings in debt of longer than 14 days of Directive 3 sanctioned companies, and also dealing in new equity of those companies, meaning equity issued after March 26, 2022. The prohibitions also apply to 50% or more owned entities of those on the sectoral sanctions lists. And some examples of major companies that have been included are Gazprom, Russian Railways, and Sovcomflot. There are many other examples as well of major companies. Other prohibitions which are quite significant are that US persons are now prohibited from engaging in transactions involving the Central Bank of Russia, the National Wealth Fund of Russia, and the Ministry of Finance of Russia. That's a broad prohibition, all types of transactions, unless there's an applicable OFAC license or exemption. We also have a number of what I call activity-based or transaction-based sanctions, which apply even if you have no sanctioned person involved. These are, for example, imports into the US of certain Russian origin products. These are primarily Russian origin energy products, so oil, petroleum. They also cover fish, seafood, alcoholic beverages, and industrial diamonds. So where this hits home is Russian origin vodka and caviar are now off the list. Unfortunately, you can no longer import those into the US. You also cannot export or sell luxury goods to Russia. And luxury goods are very broadly defined in a list published by the US Commerce Department. They can include such things as perfumes, golf clubs, and athletic clothing. Also prohibited to engage in any new investment in Russia. New investment has been a very broadly defined concept. It can include not only purchasing equity in a company in Russia, but also providing loans or financing to companies in Russia. One of the other prohibitions is on US persons providing or facilitating the provision of certain services to Russia. And we're going to talk more about what those services are in the next slides. As I mentioned, US Department of Commerce administers export controls for dual use items. In addition to adding a number of entities to its export restricted parties list, the US Commerce Department has imposed much stricter export licensing requirements on exports, re-exports, and transfers of goods, software, and technology to Russia, as well as Belarus. One of the other sanctions is that OFAC has issued determinations that certain sectors of Russia's economy are targeted or designated. And what that means is not that all companies operating in those sectors of the Russian economy are sanctioned, but rather that OFAC has the authority to impose sanctions on companies that it determines at its discretion to operate in those sectors. So if you look at this list, we have some very significant sectors such as the metals and mining sector or the aerospace sector. All companies in those sectors are not sanctioned, but the risk remains that OFAC might decide to impose sanctions on a company operating in those sectors and has the authority to do so now. In terms of the services prohibition, US persons are now prohibited from providing or facilitating provision of certain types of services to companies in Russia or persons in Russia. And those services are accounting, trust and corporate formation, management consulting, quantum computing, engineering, and architecture. There are two exceptions, which is where the services are being provided to a Russian company that is ultimately owned or controlled by US persons, or where the services are related to a wind down or divestiture of a company in Russia. Most significant services prohibition, which has come into play recently, is related to the G7 and EU price cap on Russian origin oil and petroleum products. So what this means in terms of implementation by OFAC is that OFAC has prohibited US persons from providing or facilitating the provision of certain covered services for maritime trade in Russian origin crude oil and petroleum products when it was purchased at above the price cap, which is, the price cap is currently $60 a barrel for oil. The EU and the G7 have imposed similar prohibitions. I think the jury is still out on whether this price cap is actually bringing down the price that Russian origin oil is traded at, or whether the countries who are still purchasing Russian origin oil are just doing so without involving any prohibited services. So one to keep an eye on to see whether that has a significant impact or not. This slide is just the most recent services prohibition, which is architecture and engineering services. And that came into effect on June 18th. So that's now fully effective. So that's the end of the quick overview of US sanctions and the sanctions against Russia. I'm now going to turn over to Phil to discuss sanctions compliance challenges and risk considerations in transactions.
Thanks, Jackie. I see we have a question in the Q&A, and that relates to what degree the Magnitsky Act has been leveraged in implementing the new wave of sanctions. I think the new wave has primarily been put in place through executive action, so the Magnitsky Act hasn't played a big role in that regard. So as Jackie said, I'll talk a bit about sanctions, compliance challenges, and risk mitigation in the context of transactions. And I'll focus on lending and securities transactions, but banking organizations must ensure compliance across all transactions, products, and services, particularly in the context of the complexity of the Russian sanctions regime. All relevant transaction documentation, information, and transaction parties should be screened to ensure compliance. And the transactional due diligence should identify the sources of sanctions risk, focusing on whether the transaction involves OFAC sanctioned person, territory, goods, services, vessel, or other sanction element. If a sanction element is present, the banking organization should determine whether transaction involves a U.S. element, which includes U.S. persons, U.S. origin goods, and U.S. dollar-denominated payments or other financial instruments, which generally indicate that the transaction also involves U.S. financial institutions or the financial system. Next slide, please. So key to mitigating the risk and compliance challenges in the complex Russia sanctions regime is conducting robust customer due diligence and risk assessment, which should guide risk-tailored transaction monitoring and screening and controls that are based on the sanctions risks of the customers involved. Sanctions risk assessment is one of the pillars of an effective sanctions compliance program, and conducting a customer-specific sanctions risk assessment is now a regulatory expectation. Best practice to mitigate sanctions risk through identification of high-risk customers and implementation of monitoring controls for the transactions of these customers include understanding the business of the customer and their sources of funds, understanding with whom the customer does business, as well as identifying beneficial owners and other key personnel for legal entity customers, and screening such persons against sanctions lists, commercial databases that are widely used, such as WorldCheck and Factiva, as well as a bank's own internal watch list. In addition, it's advisable to periodically screen all information collected through the customer due diligence process against sanctions lists. It is also very important, as Jackie said, to understand the ownership and organizational structure of legal entity customers, and to seek information about potential affiliation with sanctions targets, particularly considering the numerous Russian SDN designations and the application of the 50% ownership rule that Jackie described. You should seek to identify any customer that has personal nexus or exposure to Russia or activities involving Russia, including through beneficial owners, officers, or affiliated entities. In that regard, it's best practice to use sanctions questionnaire, incorporating specific questions to identify customers that engage in business transactions with Russian nexus, as well as customers located in or doing business in Belarus and countries identified as transshipment countries, such as Armenia and Uzbekistan. The Russian oligarchs are very adept in concealing their dealings, and it's good practice to always seek to identify any persons, such as undisclosed principals, on whose behalf the customer may be acting. When a bank identifies a customer with links to Russia, we suggest that the bank requires the customer to provide a written certification that they will not use their account to process any transaction that violates sanctions, or use their account to send or receive payments or process other transactions on behalf of undisclosed third parties. In addition to due diligence steps, it is also advisable to periodically screen transaction data to identify customers that have transacted with customers or counterparties in Russia, or that have been involved in trade finance transactions with respect to export or import of goods to and from Russia. And so information then collected as part of the customer due diligence and sanctions risk assessment should be incorporated in transaction monitoring controls, such that activity that is inconsistent with the CDD baseline can be flagged and reviewed. Transaction monitoring controls should also incorporate Russia-specific red flags that are identified by OFAC and in other relevant guidance documents. Let's go to the next slide, please. One more. Okay. So here I'll touch on the type of sanctions on Russia that impact lending transactions. First, a lending transaction where the borrower is a Russian SDN or an entity 50% or more owned by a Russian SDN may not involve U.S. persons or the U.S. financial system. The involvement of SDNs in lending transaction negotiation and execution also triggers potential U.S. sanctions issues. And in addition, a lending transaction with a borrower that uses the proceeds of the credit to finance business with SDNs would be problematic from a U.S. sanctions perspective if U.S. persons are involved. U.S. persons may not provide services, including lending services to block persons or SDNs. And services are deemed provided or exported to SDNs if any foreseeable direct or indirect benefit is received or provided to an SDN. U.S. persons may not be involved in any lending transactions involving borrowers in Crimea and so-called Donetsk and Luhansk People's Republics, as Jackie explained, they're comprehensively blocked territories. And then the new investment prohibitions effectively prohibits the extension of new loans to any entity in Russia. Prior to April 22, when the new investment prohibitions went into effect, the Russian sectoral sanctions prohibited extensions of credit to specific designated entities. Currently, the new investment prohibitions effectively prohibit any U.S. person involvement in the extension of credit to entities in Russia, as OFAC considers extensions of credit to be a form of investment. The new investment prohibition also prohibits extending credits to entities located outside of Russia that derive more than 50% of their revenues from investments in Russia. Drawdowns under long-term facilities entered into prior to the effective date of the new investment prohibitions may continue, provided that such credit was contractually agreed prior to the effective date of the sanctions under terms that were not modified or negotiated after the effective date of the sanctions. And as Jackie discussed, a U.S. person also may not facilitate a transaction between non-U.S. persons where the U.S. person itself is prohibited from performing the transaction. And in the lending context, facilitation may include involvement in credit underwriting, negotiation of terms, and approval of the credit. Let's go over to the next slide, please. So here I'll talk briefly about key risk mitigation steps in lending transactions. First, in addition to conducting a sanctions due diligence on the borrower and screening all other parties to the transaction, in the context of a lending transaction, a bank should ascertain the purpose of the credit and how the proceeds of the credit would be used to assess the risk of involvement of U.S. sanctions targets or indirect benefit being provided to an SDN. In addition to risk mitigation through sanctions due diligence, banking organizations should ensure that all credit agreements incorporate contractual undertakings, representations, and warranties with respect to the involvement of sanctions targets and the use of the proceeds of the credit. Risk mitigation steps for credit transactions in the context of the Russia sanctions may include review of loans and other financing arrangements to identify credit transactions involving borrowers in Russia or that are owned by Russian persons, as well as any other parties to the credit transaction that may be U.S. persons. And then such arrangements should be reviewed periodically to identify potential involvement of any newly listed Russian sanctions targets. In addition, banking organizations should periodically review the sanctions-related undertakings, reps, and warranties in such lending arrangements to assess whether they're still accurate and valid. With respect to long-term credit facilities extended to Russian-based or Russian-owned entities prior to the effective date of the sanctions prohibiting such credit, it is advisable to implement controls that ensure that such credit arrangements are not modified in a manner that violates the sanctions currently in effect. Next slide, please. One more. Okay. I'll spend a few minutes on securities transactions, as the breadth of the sanctions on Russia have triggered many sanctions compliance issues, particularly in the context of securities transactions. The Russia sanctions that have an impact in the context of securities transactions generally include the blocking or SDN sanctions, the territory-wide sanctions, and sanctions targeting capital rising by sanctions targets or targets of the security sanctions that target the securities of specific Russian issuers, including the Russian government securities. The blocking sanctions require U.S. persons to block the securities issued by SDNs and entities 50% or more owned by SDNs that are in a U.S. person's possession or control. OFAC takes the view that securities issued by an SDN are property interests of the SDN, subject to the blocking requirement. So the blocking sanctions effectively prohibit U.S. person involvement in a securities transaction involving the transfer of securities of a Russian SDN issuer, even if the transfer is effected for the account of non-sanctioned persons. The territory-wide sanctions prohibit the involvement of U.S. persons and the U.S. financial system in the provision of services, including specifically securities-related services to those territories. And I'll go over the sanctions on Russia that target providing capital to Russian persons on the next slide. But before doing that, I just wanted to note again that the general facilitation prohibition also effectively prohibits U.S. person involvement in execution, clearance, settlement, negotiation, and supervision of securities transactions between non-U.S. persons, where such transactions would be prohibited for the U.S. persons themselves. Okay, next slide. The Russian sanctions targeting capital financing by Russian persons that directly impact securities transactions include the sectoral sanctions that Jackie talked about, as well as the prohibition on new investments in Russia. But more specifically, as outlined here again, U.S. persons are prohibited from engaging in any transactions and other dealings in debt securities of the companies listed on the sectoral sanctions identification list with specified maturities, as well as companies that are 50% or more owned by the listed companies. The new investment prohibition effectively prohibits U.S. person involvement in purchases of securities issued by Russian entities. And under executive orders, U.S. persons are also prohibited from providing certain services, as Jackie outlined, and the currently prohibited services of relevance to securities transactions include trust services, which also includes a prohibition on a U.S. person from serving as a voting trustee of the shares of a Russian person. U.S. financial institutions are also prohibited from participating in any transaction involving Russian government bonds, including any secondary transaction involving such bonds that are issued after March 1st, 22. Let's go to the next slide. Here I'll talk briefly about sources of U.S. sanctions risk in the context of securities transaction. First, as a threshold matter for U.S. sanctions implications to arise, a securities transaction must involve a jurisdiction, person, or security that is subject to U.S. sanctions. Second, the securities transaction must involve one or more U.S. persons. That may be U.S. investors, customers, financial institution intermediaries, or personnel at non-U.S. entities that are U.S. persons. So, for example, if U.S. sanction compliance issues arise, where an investment manager is a US person, even if such investment manager is employed by a non-US entity engaged in asset management activities wholly outside the United States. The fact that a security is issued by a US issuer or is denominated in US dollars does not automatically trigger US sanctions compliance issues, but transactions in such securities typically involve US financial intermediaries and the US financial system, which triggers US sanctions compliance considerations. For example, securities issued by US issuers are typically held through custodial chains that involve US custodians, and non-US banks must ensure that they do not facilitate transactions that may result in a violation of US sanctions by US custodians in the custody chains. One of the challenging Russia sanctions compliance issues in the context of securities transactions is the identification of securities that are sanctioned. Fortunately, there is no list of sanctioned Russian securities, and identifying Russian sanctioned securities may be challenging, particularly in the context of complex investment structures that involve multiple offshore companies, trust or special purpose vehicles that could ultimately be owned by a block person. In the context of securities transactions, it may also be challenging to identify all entities involved in the transaction to ensure that US persons or US sanctions targets are not involved. For example, transactions involving Russian securities that are not sanctioned may have sanctions implications if the securities are custodied by sanctioned Russian banks, or sanctioned Russian banks need to be involved in the clearance and settlement of the transactions in such securities. The challenge of identifying all relevant parties to securities transactions are compounded by transactions involve complex structures or entities in secrecy jurisdictions, or in jurisdictions with weak anti-money laundering and sanctions compliance regimes, which gives rise to transparency risk and the risk that the relevant parties to the transaction may not be identified. Much like correspondent banking accounts, correspondent accounts maintained for purposes of facilitating securities transactions present higher risk and compliance challenges. A common example of such an arrangement involves introducing securities business where a firm is carrying accounts for an introducing broker. Such arrangements present heightened sanctions compliance risks and compliance challenges, particularly where the introduced account is undisclosed, or the introducing broker is based in a high-risk jurisdiction or provides services to clients in high-risk jurisdictions. Next slide, please. So some interesting questions have arisen in the context of how the new investment prohibition impacts securities transactions. Importantly, OFAC has indicated that the purchase of existing debt and equity of a Russian entity constitutes new investment. So now US persons are prohibited from purchasing and facilitating the purchase of securities of Russian issuers, both in the primary and in the secondary markets. Facilitation of the investment of Russian securities to non-US persons by US persons is not prohibited. There was a period of uncertainty after the issuance of the new executive order prohibiting new investments as to whether conversions of depository receipts to underlying Russian shares is prohibited. OFAC has since clarified that that would not be a prohibited new investment. We've seen some interesting questions come up in the context of transfer of securities between accounts, same account holder or different account holders. And in the context of transfer between accounts of same account holder, there should be no issues under the new investment prohibitions, but there could be issues if the securities are issued by a blocked person. In the context of transfer to a third party, there could be an issue if consideration of some sort is provided, or if the transfer is to a US person or made into an account of a US person. And for inheritance and donations, OFAC hasn't provided guidance, but those should not constitute new investments. that are prohibited because no value is provided by the transferee. Okay, so let's go to the next slide. There was some couple of slides here specifically dealing with custody and funds. We've seen interesting questions come up, and I thought I'd go over the kind of how the sanctions issued could arise in the context of pure custody provided by a bank. And so the question here should be, do you have a customer, custody customer that is a target of US sanctions? The adequacy of the customer due diligence is key again, as I noted, but a customer could also involve another bank that uses the bank as a sub-custodian for its own custody customers. And for such relationships, appropriate customer due diligence should be performed to mitigate the risk of providing custody service indirectly to the sanctioned customers of the bank's correspondent. The second key question is, in the custody context, is there a security that is sanctioned security? And third, for US sanctions implications to arise, in addition to US sanctioned security or custody customer subject to US sanctions, the custody service must also involve US persons. And such US persons may be a US investor for whom the bank provides custody service directly or through a sub-custody arrangement, a US sub-custodian, or US banks and other financial institutions that may be involved in the clearance and settlement process. In the interest of time, I'll skip the next slide, Jackie, and I'll turn it over to David to speak about enforcement trends and risks.
Well, thanks very much, Phil. And Jack, you can go right on to the next slide. So I'm going to run through what we're seeing in terms of trends on the enforcement side for both sanctions and export control, and where we think things are going. First, on the economic sanctions side, the players, you'll be familiar with them. OFAC has an administrative authority to enforce the economic sanctions. They operate a strict liability regime, which senior officials have recently reminded us they're not afraid to use if a company doesn't have an adequate compliance program in their view in place. The Department of Justice has criminal enforcement authority. The Danny in New York has gotten involved in actions against financial institutions that involve OFAC sanctions using a variety of state statutes. Of course, the federal and state banking regulators are quite active under principles of safety and soundness. The SEC. There was a recent case involving a Northern European bank that settled with the Department of Justice and local authorities regarding AML issues. They had ADRs listed in the U.S. and they also settled with the SEC for $413 million on the basis that the SEC believed that they had failed to adequately disclose the risks of the deficiencies in the AML program at their branch in the Baltics. Now you can see for any other bank that has ADRs listed in the U.S. that has a systemic OFAC compliance issue, that going forward the SEC could also join the party. On the export control side, Jackie mentioned BIS, which administratively enforces the U.S. export controls on commercial and dual use items. DOJ similarly has criminal enforcement authority. FinCEN. What does FinCEN have to do with export control? Well, violations of the U.S. export controls are specified unlawful activity under the Money Laundering Control Act, and FinCEN, particularly since the Russia sanctions, has been active in reminding banks of their bank secrecy obligations when it comes to transactions involving export control issues. We'll have more on that going forward. Jackie, next slide, please. OFAC's enforcement policy. Now, this is something which I find particularly interesting because it changes with every administration, and it can change during the course of an administration if national security priorities change as well. And this can have tangible effects on the outcome of cases, particularly ones that straddle more than one administration. OFAC for some time has had formal enforcement guidelines. These detail how OFAC calculates a civil penalty. It defines voluntary disclosure. It defines what they believe is an egregious violation and what the aggravating and mitigating circumstances are that they consider. Still leaves plenty of discretion for OFAC in how they apply the facts to these various definitions. They also have issued guidance on what they believe is an adequate compliance program. And they consider the adequacy of your program when it comes to resolution as well. And in recent years, they've also ramped up their regulation through enforcement. Settlements today, and for a number of years now, have included compliance commitments, addressing things such as management commitment, risk assessment, internal controls, testing and audit, training, and requiring an annual certification regarding sanctions compliance, typically over a course of 5 years. DOJ's criminal enforcement policy, we've seen quite a bit out of DOJ in the last 18 months in this area. The National Security Division has its own corporate criminal enforcement policy, in particular on voluntary disclosures. There's guidance on what they believe is a voluntary disclosure, which isn't necessarily the same way OFAC looks at it. There's quite a bit on what cooperation means. The definition of that term has changed quite a bit over the last 18 months when it comes to DOJ enforcement. And they also have their own guidance on what they expect in a compliance program. Next slide. Yes, the word of the day is evasion. Beginning in June of 2022, a few months after the initial invasion, FinCEN and BIS issued a joint alert urging increased vigilance on attempts to evade the export control restrictions involving Russia and Belarus. FinCEN in this quite clearly reminds all financial institutions of their BSA reporting obligations, and also encourages financial institutions to report to BIS enforcement authorities as well if they come across something. This particular alert includes a list of commodities that the two agencies say present special concern and strongly hint that it ought to be taken into consideration in their risk-based screening of export control related transactions. 8 months later, just in case you didn't get the hint the first time, another alert was issued, this time by 3 agencies, the BIS, Department of Justice, and Treasury, again, regarding evasion of Russia-related sanctions and export controls. This one provides a number of red flag examples and typologies regarding third-party intermediary risks. And then a few days later, the multilateral repo task force, which repo was Russian elites, proxies, and oligarchs task force, which includes the US, the European Commission, and a number of allies. This similarly gives guidance on typologies, red flags, and other resources to take into consideration in your transaction monitoring. And Jackie discussed the price cap mechanism that is in place too, and OFAC issued an alert in April regarding concerns over the evasion of the price cap. Next slide. So sanctions is the new FCPA, according to the Department of Justice. And what they mean by that is it is an increased area of enforcement concern. They have hired 25 additional federal prosecutors whose job is just to prosecute sanctions evasion, export control violations, and similar economic crimes. They've added a new senior position to the National Security Division, a chief counsel for corporate crime with respect to these issues. They're making and have made already a substantial further investment in their bank integrity unit. The initial focus in terms of DOJ enforcement regarding the Russia sanctions has focused on seizing oligarch sanctioned assets through a klepto capture task force, which could be called the Oligarch Yacht Task Force more precisely. There has been increased international cooperation because of the multilateral nature of these sanctions, and there's been a lot of press coverage about joint actions in terms of seizure and forfeiture of assets. And of course, now there's a lot of action on how those assets perhaps can be used to benefit the people of Ukraine. DOJ here is also turned to some very creative use of their seizure and forfeiture authority. Again, because the proceeds of a sanctions violation implicate the money laundering laws in the US. And we have seen them move to both the seize and the forfeit, which means they take the money out of frozen accounts of sanctioned parties if the money was sent there in violation of the AML laws. Now, we're also seeing from DOJ a lot of increased expectations in terms of the level of due diligence in trade finance, and this ties into the government alerts that we talked about previously. And there's also a lot of geopolitical considerations going on. Now, there's not a lot of public discussion about this, but you can see this in what the authorities are doing and not doing. My personal view is there's a lot of consideration going into enforcement decisions when it comes to maintaining the alliance and the united front, but we'll see how long that lasts. Next slide. The shiniest new tool in the toolbox is the new and expanded whistleblower bounty program. And if you're not aware of this, it's important for you to spend some time on it. In fact, we could spend the entire hour talking about the implications here, but I've got 2 minutes, so we'll do it fast. So back in, as of January 2021, when AMLA was signed, the whistleblower bounty for a BSA violation was increased to up to 30% of the penalties collected in cases of over $1 million. Congress recently expanded that program now to cover OFAC sanctions violations, and there's a floor on this of a minimum recovery of at least 10%. Now, for some of the sanctions cases that we're all aware of, that's generational wealth for a potential whistleblower. FinCEN is administering this program. It's been active since January of 2021. They've got a team that is sort of an intake team. If it's a sanctions issue, they refer it to OFAC. We know anecdotally that DOJ already has a couple, at least, open investigations that have come through the whistleblowing program. Now, under the statutory language, it appears that even compliance and audit employees of, for instance, a financial institution are eligible to be a whistleblower. There are regulations that are promised and are expected to be issued imminently that will put some more flesh around the program. When you think about it, though, what impact is this going to have on information sharing between banks? On escalation procedures, on the timing of how quickly you want to get information to the government before a whistleblower decides that it's in their personal interest to do so. Again, we could talk about this quite a bit, but just yesterday, we got another 3 government agency compliance note alert from DOJ, Treasury, and Commerce, this time on voluntary disclosures, describing their various programs, the similarities and the differences, encouraging companies to come forward and to make disclosures. But included in that, they described the new whistleblowing bounty program. Now, that wasn't put in there by accident, in my view. It's clear that they want companies to come forward, and if we won't do it ourselves, they're going to bribe our employees to come forward and to disclose it. So all those risk mitigation things that Phil talked about, and Jackie, in terms of the compliance steps to avoid finding yourself in a position where you've got an enforcement issue, certainly should be first and foremost in your minds. So I see we've got, I think we're out of time, but I want to thank you all. You know where to find us if you have additional questions. I want to thank Beth and the IIB for the opportunity to present to you today. This is something which, fortunately, the developments have slowed down of late, and we hope that stays that way. But the compliance challenges and the risks, I think we're just getting started. So thank you very much. And
yes, thank
Beth.
you so much to David, Phil, and Jackie. We really appreciate you taking the time today. For those who are still on this call, I just wanted to let you know that we will be sending around the slides. And I know that there was at least one question that unfortunately we didn't have a chance to answer. But I certainly hope, David, that we can take you up on your offer to maybe have a future program on whistleblower and some of the other things that we touched on and didn't get too much time to talk about. So again, thank you from the entire IIB. We really appreciate you all coming today and talking about this very important topic.
Thank you all.
Thank you.
Thank you.
Have a great day.
Goodbye.